I'm Emir Crowne. I'm an associate professor here at the University of Windsor Faculty of Law. One of the major um, maybe drawbacks of the charter is the fact that it only applies to governmental action. I mean, in theory, there's no reason why the charter couldn't apply to private action as well. And so, in my view, sort of that the restriction in 32.1, that would be a restriction that perhaps we think about excluding, have the charter apply to every sort of action, state or non-state action. And then there's the idea in Section 1 that even though we tell you there are these rights, depending on how our Supreme Court decides an issue, we could limit it or not. Seems to me Section 1, again, is one of those areas where it could be used to promote democracy, and it could be used to hamper it. It all depends on how well your judicial system works. Because that's the only way the Section 1 really works. Because, I mean, in any case that deals with a charter infringement, it's arguable that it can always be saved under Section 1. It just depends on how judges actually decide the issue. So Section 1, again, could be a type of section where you'd want to think long and hard whether do we want to set out a list of absolute rights and then say there are other rights that could be curtailed, or do we say that every right in this document has the ability to be curtailed? So to me, Section 1 and Section 32.1, those would be the ones where there'd be positives and negatives that you'd have to weigh, aside from the actual substantive rights themselves. I look at it from the point of view as to the court they've come from. So the fact that their Ontario Court of Appeal promotions, essentially, and that court, by and large, most of its work is criminal in nature, criminal appeals. I think that if there's any sort of evolution or refinement and so on, it would come in the criminal cases, things dealing with evidence, that type of thing, improperly obtained, warrants and that type of situation. So I think that the evolution in that respect would be more for the crim side of things. I don't really see the new appointees having that much of an impact, say the corporate commercial sphere, or that just for the simple reason that they're Ontario Court of Appeal, former Ontario Court of Appeal judges. Seems to me that would just be an evolution of not even an evolution, but just an encapsulation of where we are in terms of either the common law or human rights legislation, right? That it would just actually simplify it, instead of having to know the nuances of each human rights act and legislation and so on, that it would actually make the system at least more accessible in that respect. So you would know that I have this right not to be discriminated against on the basis of gender, which is fairly well known, but it's at least in that respect, it would make people's knowledge of the law a lot broader in my view, as opposed to sort of relying on a hodgepodge of human rights legislation, common law, and so on. That it would actually increase sort of this idea of access to not justice necessarily, but access to just legal knowledge. Yeah, that would probably be cruel and unusual punishment. But if somebody were to do that, I'd suggest Hill in Church of Scientology, because it deals with freedom of expression and defamation, which I think most people have an understanding of. Freedom of expression is very important to me, and my dignity, my reputation is very important to me. And so although it is a fairly lengthy and intricate case, to me that would be something you could wade into the charter with and so on, and get a sense of, because it's not really unduly technical and so on. I mean, in terms of for lawyers and law students, Aaron Oakes and somebody who's probably those types of cases, telephone delivery and so on. But Hill and Church of Scientology would be the type of case that I think most people, once you get over the length of the case itself, is something that's quite approachable.